all of this is that this is a mishmash. In addition to that, the only place in here that names what I'm going to say, I'm going to adopt Jeffrey Williams, young thug. Where did that information come from? It can be presumed that it came from the unknown neighbor, but did it come from someone else? Because it says that shot somebody named Young Thug or whoever that's supposed to be. So was Young Thug shot? Did Young Thug do a shooting? I don't know, but when it says somebody named Young Thug or whoever that's supposed to be, without this caller here asking her questions, pointed questions, saying, where did you get that information from? It is a violation of Confrontation Clause rights. And Pitt says that if you find some statements testimonial, some statements non-testimonial, you redact the statements that are testimonial. Where Young Thug, whether he was shot, it says that shot somebody named Young Thug, whether Mr. Young Thug, Jeffrey Williams, was shot or not, or did the shooting. The bottom line is that doesn't go to the emergency. That information comes from somewhere that we have the right to cross-examine. So that would have to be at the minimum redacted, respectfully. I think the whole thing is testimonial though. At the end of it, Your Honor, the two-line, in page 3 of Mr. Williams' Exhibit A, as in Elisa Alpha, if you go up to the first time that the caller is speaking on that page, it says unknown female. All right, please don't tell anyone I made this call. That does away with all of the belief that when you're in a panic and you're calling for help, you don't think about things like, don't tell them I called, because it's supposed to be so fresh that the only issue is, I need help, my building is on fire. I need help, the glass just broke and I'm covered in bleeding. I need help, I just had a heart attack and I'm laying on the ground, I'm losing consciousness. I'm not worried about, by the way, retaliation or don't use my name. So, Your Honor, for all of those reasons, or any one of those reasons, I respectfully ask this honorable court under Pitts versus State that this 911 call, and the words that they use is bears, which is B-E-A-R-S, testimony, quote unquote, against Mr. Williams and implicates the concerns of the Confrontation Clause. That is an objective standard. That is an objective standard. That is a reasonable person. It's not the caller's standard. In addition, Your Honor, under Pitts goes through the long process, and all these cases go through a long process, that the caller was or was not in immediate peril. Here, the caller is in no peril. She is reporting something of somebody else. She didn't see anything. And that's in Pitts versus State. And they specifically wrote, our highest court wrote, the caller was not in immediate peril, but was calling to report the defendant's whereabouts description and the fact he had violated a court order, and they're citing to a New York case. It's State versus Powers, P-O-W-E-R-S. So, Your Honor, here the caller was not panicked. She said it's not an emergency. I'm not going to repeat, but it's all of the issues that I am raising. If Your Honorable Court finds that this was testimonial in part, and you redact some, but you don't redact some of the call because you find that some of it's non-testimonial, that is what you're supposed to do, and that again is under Pitts.
What about if this phone call were made to thwart an ongoing crime, which arguably might be occurring? How would you respond to that?
It depends on the circumstances. So
We got this circumstance.
this circumstance is, we really don't know if there's an ongoing crime. She doesn't know. She says somebody's in there that was shot or shot.
She's relaying third-party information.
Yes, and you can't assume, at first, when I first listened to this, Your Honor, I thought, oh, okay, this is coming directly, from a listener, from the neighbor. Then I realized I have no idea who this is coming from. She never says, meaning the caller. I got this from my neighbor. It says my
She's
neighbor.
referencing some other person.
Exactly.
involved.
I don't know if she got it from a third or her network, et cetera. So I don't know where this information is coming from. So I hope I've answered your question, but in this particular circumstance, I'm not even so sure there's an ongoing emergency. And I say that because objectively, the neighbor goes back to the home. Well, let me start here. The neighbor left the home in a panic, says, this person's in my house, whatever happened, goes back to the home, and then is calling the unknown 911 caller. So clearly, the neighbor is free to use a cell phone, free to enter her home, and free to exit her home. That doesn't sound like anyone is saying, I am being held against my will. I am being accosted. I am being the victim of something. It sounds more like they are reporting that a shooting happened and either the person was shot or the person shot someone, and that is not the ongoing emergency that we are talking about. Through this caller, it would be different if it was the neighbors supposedly calling and saying, this is what's going on, adopted here by the unknown female, then I believe that it's a harder case, but we'd have to analyze it if those were the facts, because I've changed the facts. And leave and call, and when not answering the phone, was that in 5-minute time span? Was that in an hour time span? Was that in a 30-minute time span? Brian, that's wrong, or I disagree with you in part, whatever. I'm going to redact parts of it. Then your honorable court is back through the hearsay analysis, because it's still hearsay. Because it's clear that this did not she comes from third parties, neighbor, maybe we don't know, and because we don't know who else is here's problem for Mr. Williams if you let it in. So Stradlin, Harry, TLAN versus state, which I cited before you're on court. I said earlier today, and I'm just quoting from the court's opinion, only in the appeal opinion, only after a court determines is are two of them. And the first one I have is the present sense impression. Present sense impression, that person has to saw a person jump out of the building that I was in, and I saw the body come through my window. I saw that, and I relate come out, and then gun. I can relate because this person all is in a panic. When came home, went back to her home. She called. I called her. She wouldn't answer. She called me. State stresses him. The caller of 911 again while the caller's on 911. Finally, Your Honor, present sense impression is, it happened so fast, I observed it, and I'm relating it. There's no time to think about repercussions of what you're saying. It is the instant. Cases say, and it's in the Grimes, Grimes versus State, 346 Georgia Appeal 518, 875 Southeast 2D 500, 2002. And there the second highest court in Georgia wrote that the statement was not a present sense impression when, at the very least, there was an intervening walk or drive between the event and the time of the statement. So here, Your Honor, it can't be a present sense impression for the caller because we know already that the statement allegedly happens through the neighbor leaves, the caller then, unidentified caller to 911, is calling the neighbor saying she won't answer. So there's the walk or the drive. It's not a present sense impression, and it's hearsay. It's those are the two layers of hearsay, double hearsay, that the state has to meet both exceptions, because you have the statement being made by the caller, you have the statement being made by the supposed neighbor or third parties. So, Your Honor, we don't have a designated time for which this statement was made, and therefore this is not contemporaneous, and present sense impression does not apply. The excited utterance exception and present sense impression, by the way, is 24-8-8031. The excited utterance exception, Your Honor, is 24-8-8032. CAD reports, 911 calls contain inadmissible hearsay. That's in Kamusko, Kamusoko versus State. That's at 362 Georgia Appeal 2768. 68 Southeast 2D 253 is 2002 case. And Your Honor, specifically the Court of Appeals discusses that in the very top. It's under Division 2A, as in Alpha Lisa. We turn first to Kamusoko's argument that the CAD reports were inadmissible because they contain hearsay. It is undisputed that CAD reports in this case included statements made by victims, witnesses, and officers to the 911 dispatchers. So what we have to do under excited utterance is figure out whether the statement related to a startling event or condition while the declarant was under the stress of the excitement caused by the event or condition and excluded by the hearsay rule. Here, there was no stress seen by the caller. The caller's stress, quote unquote, is the neighbor comes to see her. But the caller says again, and I feel like I'm repeating, this is not an emergency. There is no stress. The caller is saying, I don't want to be involved. I'm not giving over my name, my telephone number, or my address. The caller is saying, hey, I'm thinking about it. I'm going to talk low so nobody can hear me because I don't want retribution. All of that goes to this is not an excited utterance because there is time to think about fabrication, coaching, or confabulation. And that is the foundation of the excited utterance exception to the hearsay rule, is that such a statement is made under circumstances that completely is the word used by the courts, eliminate the possibility, even the possibility of fabrication, coaching, or confabulation, and therefore the circumstances surrounding the making of this statement provide sufficient assurances that the statement is trustworthy and that cross-examination is of, and this is what I'm stressing also, absolutely no benefit. Absolutely no benefit. The critical inquiry on whether the excited utterance exception to the hearsay rule applies is whether the declarant, that is the speaker, is still in the state of excitement resulting from that event when the declaration is made. Well, this caller can't be in that excited state because she is claiming this is not an emergency and she has the wherewithal to say, I don't want to be involved. She says that at the beginning, it's not an emergency. At the end, her last words are, her second last words are, don't tell her when I made this call. So, Your Honor, in this case, I respectfully request that the excited utterance as does not apply either the hearsay. So I believe it's barred by confrontation clause. I believe it's barred by the hearsay rule. If Your Honorable Court goes further, though, there are two layers of hearsay. How did the neighbor get this information? How did the neighbor know that, and I'm adopting it in the most light, unfavorable to Mr. Williams. I'm not saying I agree with this, but Mr. Williams shot someone. She never said, I saw it happen. No one's saying that it shot someone in her apartment. So she was told that. Was she told that by Mr. Williams? I don't know. Was she told that by a neighbor? I don't know. The caller also says Mr. Williams was shot or Young Thug was shot. So you're getting conflicting information, how you want to listen to it. It doesn't matter. But that caller is relying on the supposed neighbor. And we don't know how the neighbor got that information. So without that information, there are two levels of hearsay that have to be cleared by the prosecution. They have to run through both of those walls after they run through the stronger wall of a confrontation clause issue. So I ask your court not to deny this motion and to grant the motion in whole. If you grant it in part, I would like the Honorable Court to focus on the Young Thug comment because nobody knows Young Thug is in the apartment, Young Thug got shot, or Young Thug shot someone. And without that information coming in through a proper means, Your Honor, we are totally hamstrung. As the court knows from being a litigant, as well as I'm sure I've never had the honor of wearing a robe, but from watching people get cross-examined, that is the, I think it's called the crucible that separates American jurisprudence from every other trial in the world, because I think the U.S. Supreme Court and Georgia Supreme Court has said that that is the ultimate truth-telling event. And Mr. Adams and I cannot confront any of these people in this case. And just playing a 911 recording, it is impossible to get information from that recording. Your Honor, I'll answer your question. I hope I was beneficial to the court, and I want to thank you.
Okay. All right. Thank you, sir. All right. Yes, Ms. Love. Go right ahead.
Thank you, Your Honor. Judge, I'll start with the words panicking, doesn't know what to do. Her mama and her baby are in there. I'm trying to get her out of the house. She won't answer the phone. She doesn't know what to do. Please don't tell anybody that I made this call. I'll refer first to the case that Mr. Williams brought up as being the most illustrative of the point that he seeks to most emphasize to this court, that somehow the 911 call is inadmissible because it violates the confrontation clause, and that's Pitts versus the state. On page 3 of 4 of the copy of Pitts given to the state and to the court, I believe by Mr. Williams, the court does an analysis, and specifically in paragraph, the first paragraph on page 3 of 4, it notes that coming from page 2, that the caller Powers called to report a defendant for a recent parole violation. And the court noted in Pitts that the caller made the call to report a completed violation of law, and noted that the caller's sole purpose was to make a report of the fact that the caller or that the perpetrator had violated an earlier court order to establish evidence that could be used in a future prosecution. And the court in Pitts noted that for these reasons, the statement was testimonial. It then went on in paragraph 2 to look at the caller in Pitts.
Awaken your first portal and tread on towards that which is boundless.
That my neighbor is in a panic is that listening, and the reason that we wanted to play the call for the court is that it is apparent that the sole purpose of the call is to get assistance for what the caller perceived as an immediate danger. She is akin to a person witnessing something violent going on, being afraid of whomever it is that is committing the violence, seeing a policeman pass by, grabbing the officer and saying, "Hey, go look over there in that alley. So a man is attacking a woman. Don't tell him I said it, but Johnny is over there beating his wife, but you didn't hear it from me. But go help the wife while Johnny is beating the wife." The assertion that because the caller does not want to make her name known to the police or does not want to get herself in trouble flies in the face of the obvious fact that those facts make it apparent that this caller is not calling to establish any evidence for the purpose of a future prosecution. Her sole reason for calling is to get this person out of her neighbor's house. And this is not some secondary, third party kind of situation. The caller herself has experienced her neighbor coming to her in a panic. So we get past the confrontation clause quite quickly if we simply listen to the call and listen to the information being shared. a testimonial circumstance is akin to somebody sitting in an interview room, giving testimony that they know will be used in a future prosecution. This is a woman who is so frightened herself, she doesn't want to call any attention to herself, let alone have anything she says be used in a future prosecution. As a matter of fact, us using this right now is probably the very opposite of what she ever intended to happen, because her sole purpose was to gain aid and assistance for that baby, that mama, and that neighbor that came to her saying in a panic, "Young Thug is in my house." So our first argument, Your Honor, is that this is not a confrontation clause issue by any means. Just to give the court a little bit of background. On this date, September 11, 2013, officers had gone to this apartment for a reason altogether unrelated to shooting or anything like that. When they got out there, they heard gunshots and they saw Walter Murphy, who we later learned was Walter Murphy, shooting at a man named Derek Dotson. The officers turned and went to pursue Walter Murphy, and when they did, he jumped into a red Nissan. And they noted that there were 4 individuals in the Nissan. The Nissan comes, speeds off, crashes over a wall, and crashes into a brick wall. 4 people get out running. The CAD report relays exactly the sequence of events. We will be entering into evidence 911 calls, the first 911 call that got the officers out there, and then the court will be able to hear the sequence of events. And around the time that this person made this call, just before, the court will hear officers saying, one just went under the car, the other one went a different way, and they're describing the places that each one of them went. So in the midst of all of the commotion that is going on, matter of fact, we have 2 different numbers, 2 different case numbers that are associated with this particular case. One ends in 1038, one ends in 1308. They get another call that they don't even realize is related to the call involving the shots fired. And that other call is the 911 call that the court heard today. And when they reached out over the radio and said, "We got this caller who's calling in about this guy, the shooting at Summerdale, Young Thug," they then learned that it's related to the first series of calls. And that's how they all got put together in the first place. So it doesn't happen in a vacuum. It doesn't happen after any prolonged or any period of time whatsoever. It's actually a series of very fast-paced events that take place. So the car goes over the retaining wall, the 4 occupants get out and run, the police are telling each other over the radio where the occupants are going, and in the midst of all of this, the police call a woman identifying her neighbor, having her in a panic just a moment ago, and now she's not answering her call. For all she knows, that neighbor is in there dead. The reason that she is saying what she is saying about the shots and the police, she's not even able to get it out in a very cohesive way. She's saying, "I don't know, just come now." Her
who the unknown female is talking about. I assume that you're not bringing the unknown female or the neighbor in. Is that correct?
So, Your Honor, that is correct. And that would go to the issue of hearsay that I'll address in a moment, apart from the confrontation issue. And I do want to point out in Michigan versus Bryant, our highest court notes that an assessment of whether an emergency that threatens the police and public is ongoing cannot narrowly focus on whether the threat solely to the first victim has been neutralized, because the threat to the first responder and public may continue. So when the court is asking whether we're going to bring them in or not, I, with the court's permission, will speak to those matters.
Well, I don't get to that until I determine whether or not it's a confrontation or
Yes,
it's
Your Honor.
testimonial. But the issue is, she starts out by saying it's not an emergency. Okay, and I'm looking at this because I'm being asked to exclude comments that or statements related to this particular 911 call. Ordinarily, 911 calls have to be looked at on a case-by-case basis. And I think that Pitts and Spratlin and Grimes all kind of indicate that. So I got to look at that. But I also am looking at the fact that her statement is, I have no idea, baby. I promise you, I can tell you all. I don't know. The only thing I know, she came running. She came to my house. She told me that the guy that shot someone named Young Thug or whoever that's supposed to be shot someone, and that guy is in her house. So we don't really have, I mean, there's no granularity. I agree with Mr. Steele about what is actually going on. I could parse out several hypotheticals of what she calls or claims may have happened. And it's unlike Pitts and the other cases where you've got somebody who's making that call. You're basically, it's already in a third party situation, because she's relating kind of what she thinks is going on. Now, so that's kind of what I have to kind of decide to begin with. Is the call primary purpose testimonial for the purposes of prosecution or gathering information for later? I can see how it could be either one, but I have to kind of take a look at the facts and circumstances to make a determination as to that. So, but unlike Pitts, the victim is making those calls.
So, Judge.
So in this case, you got a third party who really doesn't we don't have granularity of what she's talking about. I mean, and so I have some problems with that to begin with.
So I would like to separate out and point out that the content of the call, the fact that there is a matter that she is trying to get the police there to address, and the credibility of the content of the call is a matter, again, that I believe belongs within, is it hearsay and is there an exception? Before we get to what she is saying as it relates to whether or not this is trustworthy, and I believe with respect that is what the crux of that particular issue that the court just pointed out, is it trustworthy? This is a third person making a call about something she just experienced. So is what she is saying trustworthy?
I'll give you that much. Okay.
And so for the purposes of that, Your Honor, I believe that will fall after the court makes that determination as to the confrontation clause. And as in Davis versus Washington, Your Honor, 547 U.S. 813 at 822, the United States Supreme Court distinguished, of course, testimonial and non-testimonial statements, saying that non-testimonial statements, when made during a police interrogation under circumstances that objectively indicate the primary purpose of the interrogation is to enable police assistance to meet an ongoing emergency. And that is exactly what, even if she says it's like it's not an emergency. Don't make a big deal out of this. Come get this person out of my neighbor's house. Essentially, that's what she's saying. I don't want to call. The reason she says, and it is apparent from the call, objectively listening to it, the reason she says it's not an emergency, even though her voice is panicked, is that
I don't think her voice is panicked. She's kind of just talking. I mean, she's talking in low tones. I don't, at least from the court's perspective, I'll disagree with you. I don't think.
Yes, Your Honor.
I don't think it's an emergency.
Yeah.
I mean, she herself says it's not an emergency. She's, like I said, I got to look at the primary purpose for the call. Is the primary purpose for the 911 call to provide information that may be used later, or is it for an emergency or some other reason? Pitts kind of distinguishes because you got somebody who's getting their, for lack of a better word, their behind torn up, and she's calling, and there's certainly where it could be argued that truly is an emergency. In this particular circumstance, it seems like she's relating information because that's the first thing out of her mouth. I can't discount that. The first thing out of her mouth, she says, not emergency, because 911, what's your emergency? And she's not saying, hey, my neighbor is getting blah, 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 or that I heard this and this, and I've seen this, and that's kind of where we are. Where she's relating a third party. I mean, and that's kind of that's the issue of whether or not I got to struggle is whether or not it's testimony or for the purpose of primary purpose. Okay. I could see how I understand the state's argument. I understand the defense argument. But that's what I got to kind of wrestle with to begin with. And then I'll decide whether or not it falls under any of the exceptions to the hearsay rule. I agree with Mr. Steele. You didn't give notice under the residual hearsay, so I'm not going to consider it under that.
Your Honor, and Mr. Steele did point out the very last argument that we made and sort of went past the first two. But going back,
you need to focus on whether it's testimonial, because if I don't find it's testimonial, I don't have to go to the other two. The second prong. First step is if it's testimonial, it ends there. If I find that it's not testimonial, then I'll move to whether or not it falls within a hearsay exception. But I'm not convinced it's not testimonial yet.
Your Honor, I'd ask the court to look at Varner versus the state, 306 Georgia 726. Your Honor, and in Varner, the court states.
What was the citation?
306 Georgia 726, specifically at Penn site 731, Your Honor. And it's on page 6 of 10 of the copy that I believe was provided to the court by Defendant Williams of Varner.
I don't think I have Varner.
Okay.
Oh, wait. Before I start telling you that. No, I don't have Varner.
Okay, it's at Penn site 731, and that was again 306 Georgia 726 at 731, Your Honor. And in Varner, Your Honor, the court notes that an assessment of whether an emergency that threatens the police and the public is ongoing cannot narrowly focus on whether the threat solely to the first victim has been neutralized, again, because the threat to the first responders and the public may continue. In the case that we have here, Your Honor, if we listen to, and the court has listened to, the 911 call and what the caller is saying to the police, she is simply asking them to come now. And we can, if the court would prefer or like for me to play the call again, just so that I can point out those areas, I would like to, with the court's permission, play that 3-minute call again.
I've listened
Okay.
to the call. I mean,
So when the caller says, just come, she's in there and she's not answering. just come. You've got to come. She's in apartment C. We're in Summerdale. She is giving instructions to the police, to the 911 operator, how to get to where her friend is. She's saying, the only thing I know is she came running to my house, and she's cutting off the 911 operator. So, Your Honor, even if it is not in a tone that the court would say is a panic tone, she is so eager to get the police there that she cuts off the operator on multiple occasions, just trying to tell them to get there. She is describing, as she is talking to them, the 911 operator says, okay. And after she says, if the court is looking at defendant's transcript, just so that we can get past this part in an expeditious manner, the 911 operator, after she says, okay, that's fine, okay. And she's saying, I don't want to talk loud. I don't want to get nobody. I don't want to get myself in any trouble. So she said, I don't want to get the person over there in any trouble. I don't want to get myself in any trouble. I don't want anybody in any trouble. I just want my friends safe. She's not saying, I want somebody who said somebody might be in trouble. She's saying, my friend came here to my house panicked, as she doesn't know what to do. And she went back to check on her mama and her child, and she's not answering. And it's all happening in a matter of moments. And that's apparent because of the way that the calls come through and the radio traffic comes through. I tried to reach her. She doesn't say, she just called back and said she's okay. Her primary purpose is to get assistance over there, to have someone come and get the person out of her friend's house. I don't want to talk loud because I don't want to get myself in any trouble. And so she's talking to the operator. The operator is saying, okay, that's fine, okay. And then the caller is saying, but she's got her mother and her child in there. As the operator says, okay, all right, and before the operator even gets out all of her words, the caller says, I just tried to call her cell number. I just tried to call her. I just tried to call her, and I have no idea. So the operator is trying to get what information one might argue is information that someone could use later for the purposes of a trial. She says, who was shot? She's saying, I don't know. Look, all that I know is my neighbor came running to my house, and she told me that the guy that shot somebody named Young Thug or whoever that's supposed to be, shot somebody, and the guy is in her house. So I don't know how y'all can do that. I'm trying to get her out of the house, and she won't answer her phone. I just tried to call her phone, and she got her baby and her mama in there. And then they're trying to get information from the caller that could be used later in a future prosecution. Okay, do you want your name or number? She says, no, please do not call me back. He knows my children, and no, I don't want him to come back and retaliate against me. And then the operator is saying, okay, all right, ma'am, where are you? Do you want to give me at least where she is? She's given the description, the Summerdale townhomes, not the old Summerdale, the new ones. And then she's saying, basically everybody is standing out there. So apparently she's trying not to be loud. She doesn't even want the people outside to hear her. And she says, I'm trying to get her out of the house and her mama, but they won't answer the phone, and she don't know what to do. She's panicking. Building C, come around and come through the gate and come around. I'm not sure what the number is on her apartment number. Please don't tell anybody I made this call, but come around. She is imploring them to come. This is the epitome of somebody imploring another person, please come give assistance. I believe that there is an ongoing danger. Without saying my neighbor could be dead, her mama could be hurt. She's saying the words that she believes will get the police to her. She's telling them, like, there is danger here. This is not just, if she was just calling to say, I want you all to have record. I mean, I've called to report a tree being in the road, and I'll say it's not an emergency, but somebody needs to come and move this tree. It's in the middle of the road and I'm seeing people swerving. Somebody needs to come and remove this tree now. I'm not calling for the purpose of establishing testimony for a future prosecution. I'm calling to have somebody come remove the tree in the road. And in the same way, when she called, she's saying, I'm not calling, to set this up in any future way, but I need you to come get this man out this woman's house.
All right, let's put a pin in that. Move on to do you believe if I do find it's not testimonial, how are you going to overcome, or what hearsay exception does it fall under? Because it's clearly hearsay.
Two
So
hearsay
what
exceptions, Your Honor.
exceptions do you have? And also, how do you deal with the fact that you have no speakers? You don't have any declarants. And you've got basically, you've got double hearsay.
Double
Got
hearsay.
double hearsay. So,
And of course, Your Honor, in 24-805, the new evidence code specifically addresses hearsay within hearsay. So it's not like a taboo subject. Hearsay included within hearsay shall not be excluded under the hearsay rule if each part of the combined statement conforms with an exception to the hearsay rule. So let's start with the internal hearsay, if you will. The person coming to her apartment, because that's the most deeply embedded one. She describes her as coming to the apartment in a panic. Her mother and her child are in the apartment. She needs help and she's scared. And she goes back, she relays to her, he just shot somebody. He's in my apartment. It's apparent that it's well known what's happening because she's describing everybody is out here. She is in the Summerdale, in the community that is the area where the shots took place, where the court will hear evidence of officers and they're responding to this shooting that took place. So everybody can hear it. She's there. She's relaying to her neighbor in a panic. The neighbor is describing, the neighbor's present sense impression was she's observing this person in a panic. This person in a panic is making excited utterances to the neighbor that calls 911. So the excited utterance comes from the person who the neighbor calls 911 to gain assistance for. This panicked friend of this caller comes to her in a panic. She's telling her, my mama and my child are in the house. And this man, Young Thug, who just shot somebody, or a shooting just occurred involving this person, is in my house. She doesn't even tell her to call 911. She just comes to her for help. She's not trying to establish anything. Of course, the courts put a pin in the Confrontation Clause issue, but she's not even trying to establish anything for any future prosecution. She's just trying to get help. And the neighbor, being a good neighbor, she's like, I can't help him. I don't have any way to help. I don't want anybody. I got kids. He'll come after my kids. So she calls and then tells the police her present sense impression. She is relaying information that she got, and she herself is still under, the neighbor that calls, she's still under the impression of what just occurred. She's still under the stress of her neighbor having come to her in a panic.
but it's not an emergency. Remember, she started out by saying that.
It's an ongoing danger. Emergency or ongoing danger. The court literally addresses them both and doesn't say, and it says to avert a crime in progress or to seek assistance in a situation involving immediate danger. So where I might not consider a tree across a road where there's heavy traffic coming fast an emergency, the police might, the person that hits the tree and crashes, and ends up paralyzed might have considered it an emergency. The fact that I don't use the word emergency doesn't make it any less of an effort to seek assistance in a situation involving immediate danger. Her words reflect she's panicked, she's not answering. Her mother and her child, she has said every hot button word that would get assistance quickly to any objectively listening person. if someone called you and said those very same words to you, if a neighbor of yours called you and said, oh my God, Sally across the way just called, she just came over here panicked, and now she's in the house and she's not answering. She just came over here. She said this guy that just shot somebody is in her house. I'd ask Your Honor, what would Your Honor think? And what would Your Honor do? Would Your Honor consider that call from your neighbor one that the neighbor is making to establish some future prosecution? Or would Your Honor immediately go and try and gain help for that person that your neighbor just told you about? Your Honor may well go over there yourself and see, okay, this is a dire situation. Would Your Honor not consider that an immediate danger situation that needed addressing immediately? If someone called you and said exactly what this person said to her, Judge, I don't know, but our neighbor just came over here in a panic. Somebody's in her house. A shooting just occurred, and she came over here in a panic, and her mother and her child are in there, and she doesn't know what to do. Can you go get them out? She's simply asking for assistance in what she perceives as an ongoing danger, an ongoing threat. There is not a way to perceive this as less than her attempting to gain assistance in a situation involving immediate danger. So the fact that she is telling the 911 operator what excited utterances she just heard the neighbor make, and the fact that she herself is conveying to the 911 operator her immediate impression, her own stress that she's under. So
How can I tell that? I understand the original declarants coming running and saying somebody's in my house, okay? But how do you, the second, that's the original declarant. The second declarant, how do you come up with the fact that she falls within that particular exception?
Yes, Your Honor. She falls within two. So the first one that I would say that she falls within, Your Honor, is present sense impression. And of course, that falls under 24.8031, describing or explaining an event or condition made while or immediately after the declarant perceived it. She said, my neighbor just came over here in a panic. She doesn't know what to do. I stay over here in Summerdale. The guy that shot the guy over here off Cleveland Avenue, he is in my friend's NIM apartment, and she is panicking. She doesn't know what to do. Not she was, not she had been, not she used to be. She is now, right now, he is in her apartment, and right now she is panicking, and right now she doesn't know what to do. She's saying, right now, police everywhere out here. She's saying, was somebody shot recently? She says, yes, about 5 police everywhere out here. She says, it's over here on Cleveland Avenue, Old Hateville and Cleveland Avenue. I don't want to talk loud. People are still right there. I don't want to get myself, I don't want to get anybody in any trouble. My friend, she panicking. She is panicking, not she was, and she don't know what to do. But she got her baby and her mama in there. Not she had, not she used to be, not she was. Her baby and her mama are in there. I just tried to call her. Not 20 minutes ago I called and she didn't pick up. I just tried to call her. She cannot make it any more apparent that this is something that she is perceiving right in that moment. She dialed 911 because she can't get the panicking friend who is in her apartment with a man that shot somebody and her baby and her mama, while police everywhere out here. And I'm gonna talk low so can't nobody hear me, so I don't get in trouble. And don't tell him that you even got this call, because I don't want him to come and retaliate against me. And I got kids that he might harm. She can't make it any more apparent that this is something that she is experiencing and that her friend is experiencing as she is talking to the 911 operator. Additionally, Your Honor, I would argue that the caller, the 911 caller, under 24-8032 is making an excited utterance. Because even if she is not sounding panicked to the court, her hushed voice, she is sounding out of breath at times. She is saying, expressing urgency through her words. She's relating a startling event or condition, the fact that she just came over here panicking and now she is not answering her phone. So her words are admissible under both the present sense impression, 24-8031, and the excited utterance, 24-8032, exceptions to the hearsay rule. And Your Honor, the excited utterance exception looks at, as with the present sense exception, it is not necessary that the statements be made contemporaneously with the startling event or condition. In other words, the panicking person doesn't have to be standing there panicking while she's making the call, relaying the information. She was startled by her neighbor coming to her, telling her this information. Her neighbor is startled by somebody coming in her house that doesn't belong there, that was just involved in a shooting.
Is there going to be other evidence through testimony, witnesses, and or other related 911 calls for this incident?
Your Honor, there is going to be other evidence that Jeffrey Williams was involved in this shootout in the shooting and the.
I'm talking about this particular incident on September the 11th of 2013. Meaning, because to your point, is there going to be some other evidence or some other testimony saying, hey, we were called to a blank incident about at this location. There are multiple 911 calls, or there are witnesses to testimony to bring that out, because you're telling me it was an emergency. So if there's other surrounding circumstances, as you said, I'm supposed to take a look at it in context, not a vacuum, then that might be an issue I need to kind of consider, because I'm only hearing one snippet. So is there going to be more
There are.
context evidence to this particular issue?
There
And
are,
So
actually.
what is that context you're gonna present?
A few things. As I said, regarding the 4 people who jumped out of the car, there's going to be an officer's testimony that she was chasing them in a particular direction, that one went in one direction and another went in the opposite direction. And when she went to chase them over the wall that she was chasing them over, she was called back and she had to put her attention on Frederick Prothro, which was a person who was shot during this incident. There will be testimony, I expect, from a witness who will say that while they were running from the police, that shots were fired inside the car, that Young Thug, or Jeffrey Williams, actually had a gun, that he, Walter Murphy, and Frederick Prothro had a gun, and that Jeffrey Williams or Walter Murphy was probably the person that actually fired the projectile that hit Frederick Prothro, because while they were fleeing from the police, 3 shots went off inside the car. There will be testimony that when they fled the police, that defendant Williams ran in a particular direction, which we believe will be in the vicinity of the description that this caller gave. for her friend's apartment. There will be testimony that, that's it. That's the general. And then, of course, as I stated earlier, the 911 custodian of records in explaining to me, because I had the question, how did we get from 1038 to 1308? Was there a mix-up? And she specifically said, no. When that call came in, when the 911 dispatcher sent it out, when they called it out, they were then told that call is related to the 1038 call. That is a part of this call up here. So that's how they even end up, they're on one CAD report that I have, and were it not marked up, I would show the court that particular CAD report. And we do intend to introduce as evidence that CAD report that has that these are two related events. And in fact, the remaining reports that lead investigator Velasquez uses in the entirety of this investigation has that 911 call number attached to it. It's the entire case file is ending in 1308. So in fact, this particular case, the way that it even looks in all of the discovery given to everyone in this case, the case file case number ends in 1308, which is started and initiated by this call right here. And of course, the excited utterance exception doesn't require that a declarant express any particular emotion when making the statement. That was information that I shared with the court for the court's consideration when making the analysis, but it is not required. And
I have two declarants. I have two declarants that aren't here though, right?
Yes.
So how am I supposed to work my way through through whether or not they'll fall within both exceptions to the hearsay?
Well, as I stated, Your Honor, the first one is the caller herself describing her present sense impression, what she is perceiving.
Okay, then you got this other unknown declarant who is perceiving this from the first declarant.
Right, and what she's perceiving is she's panicked and she doesn't know what to do.
Okay. All right. I may have to hear a little bit more. All right, Mr. Steele, anything else? It's almost 11 o'clock.
And Your Honor, if the court wishes that I provide anything in particular, I will do that.
Yes, ma'am. All right, Mr. Steele, address for me, the state is focusing on the issue that in the totality of the circumstances, it could be deemed as an emergency. So how would you respond to that? They pointed out these different statements, and also in the totality of what was going on at that point in time, why wouldn't this be an emergency situation?
The state's recitation of facts are not accepted.
Well, I'm just looking at the transcript you gave me, in addition to what the state's proffer is. So I think some of the statements in here would be indicative of somebody who's trying to kind of, who may be experiencing or making a call for an emergency situation. I'm just asking you for the argument. So what would you say about that?
First of all,
Without conceding anything.
how the information comes that Young Thug was shot or shot someone, we have no idea, because that's supposedly at another time. And there is no evidence that there was a shooting in the car. There's no evidence that there are 4 people in the car that the perpetrators are fleeing from the police. It is totally up in the air. You're going to see it because it's about to come out this week before your honorable court. There are 3 people in the car. There are some people say 4. Some people say 3 people are men. 1 person's a woman. There's a woman driver, yet we have the actual person who was apprehended is a man driver. His name is Adrian Bean. This is a total fight, quote unquote. And the only person who is on any 911 call, to answer your question directly, saying anything about Young Thug, is this call. And we don't even know where that information comes from and who is supposedly shot. And there's no one shot on Cleveland Avenue. This is not a shot call. The police come out to an suspicious vehicle in that same apartment complex, Somerville apartment complex. Then Adrian Bean is driving a car, and there's an unrelated armed robbery of a man named Mr. Dotson, who unfortunately passed away before our trial, unrelated to this case. The police see Mr. Murphy flee back to the vehicle that Adrian Bean's in. Police tell him to stop, and that vehicle then strikes the police car. That's the second issue. There's nothing about a shooting on Cleveland Avenue. There's nothing about Jeffrey Williams or Young Thug being shot or shooting. And that information has to come from some source. That source is not here. So to answer your question, is it an ongoing emergency? No. No one says it's ongoing emergency except when no one says it, because the caller says it's not an emergency. This is the only issue. It stands alone. Everything else is dealing with Adrian Bean, Walter
Well,
Murphy.
what about there are police out here everywhere. My friend, she's panicking. She don't know what to do. She got her mama and a baby in there. I just tried to call her cell number. She's not responding. So how could that, or why would you say that's not an emergency without dealing with this issue of the unknown female and the statements about?
Because it ignores three factors. One, call starts as I heard you say twice. It's not emergency. Second, the neighbor leaves the apartment to tell the caller, yet doesn't call the police herself, doesn't flee the apartment, goes back to the apartment, presumably. I don't know where she really goes, but the caller says she won't answer the phone, but then on the same call, the caller says, that's them calling me. So the neighbor who's in this quote unquote panic has access to her phone. This is all of the hysteria, and I'm talking low, all that is added for flavor by Ms. Love. That's why we need the witnesses here to cross-examine. So I'm not conceding that it's an ongoing emergency because I'm taking the caller for what she said.
All right. Give me a few minutes, folks.
Okay. Thank you, sir.
I'm being recessed.
And Your Honor, does the court want not the tab reports that I was talking about?
No, not yet. No, thank you. Chris.
Whatever you do it for less at Harbor Freight.